If you're a homeowner in the Los Angeles area and you were thinking about filing for bankruptcy, wait until you watch this video. I'm talking to Rory Vowinkle from Vowinkle Law about the bankruptcy process, about stopping foreclosures, about the qualifications for a Chapter 7 and a Chapter 13. It's really informative, and you definitely want to watch the full video to make sure that you have all the information before you file for bankruptcy. Rory, thank you so much for joining me today. I am really excited to talk to you about bankruptcy and how you can help protect consumers and homeowners here in the Los Angeles area. Rory Vowinkle is with Vowinkle Law, and I'm going to start right off the bat with a good question that a lot of people ask. What is the different types of bankruptcy, and how does that affect homeowners here in the Los Angeles area?
Sure. Well, first and foremost, thank you for having me on. Thank you for caring enough to have me on here, hopefully answer some questions. There's just so much misinformation regarding bankruptcy and homeowners. They think it's such a scary step to take. So I'm happy to provide some information for people, especially homeowners. It can be a real valuable tool. So to answer your first question of what's the difference between 7 and 13 are the two chapters that are for individuals mainly. Chapter 7 is what they call the fresh start bankruptcy. It's a pretty straightforward process. You're done in 90 days, get to keep most of your assets, if not all of them. But you have to qualify for that. You can't make too much money. And it's based on the state median income. For California right now, it's just a little under 72,000 for an individual. But it's based on household income size. So if you're married or you have other people in the household, it goes up. So if you got 3 kids, it can be up to 100,000. If you got 2 people, it's like 85,000. So it kind of fluctuates, but generally you can't make too much money to file a Chapter 7 bankruptcy. Most people want to file that because you are done in 90 days, it wipes out your debt, and you get a fresh start. The other type of bankruptcy is a Chapter 13 bankruptcy, and that's for people that do make above that median income, and it requires them to pay back a portion or all of their debt over 3 to 5 years, depending on what your plan is. Now, the Chapter 13 has a lot of benefits, though, even though a lot of people don't want to file it. And what that does, especially for homeowners, is it allows them to buy themselves more time. It actually has 3 major benefits. One, if you're just looking to buy more time from a foreclosure, let's say, then it buys you anywhere from 3 to 6 months. And that allows you to list the property, go out and market it, and get it sold so that you're not losing a lot of equity through the foreclosure process. Number 2, it also allows what's called a mortgage modification mediation program. So after the recession in 2007 and 2008, a lot of people were hearing modifications. And there were a lot of different places that were trying to do them, and a lot of lenders were offering them. So the bankruptcy court got involved. And if you do file a Chapter 7 or 13, you can apply for the MMMP, Mortgage Mediation Modification Program. And that's sanctioned under the bankruptcy court. So what the benefit of that is, you get the automatic stay protection so the lender can't foreclose while you're working on this modification. So that's always the fear, is you're working with your lender on a modification and boom, they've foreclosed on you in the middle of the process. And even though there's some protections out there from the state, that was happening very often. So it's good to have some accountability for the lender through the Chapter 13 process.
Yeah, I remember during 2008 through 2010 in Vegas, I did a lot of short sales during that time period, actually probably through 2012. And there would be situations where, we're trying to work with the lender and we're trying to come up with the better terms for a modification, and they end up foreclosing on the house anyway. Like, it was super frustrating because we're trying to do the right thing, but some of these lenders just keep moving forward, and the left hand is not always talking to the right hand. So you're saying that with Chapter 13, it would basically it would stop the sale from happening, and it would force the lender to the table in order to modify some terms.
Yes, and the requirement is they're supposed to act in good faith during the bankruptcy, or they can be sanctioned by the court. So, in a lot of instances, you submit paperwork and they just would never review it for 9 months, right? So at least you know that you're going to get at least a review of it. And then sometimes it's helpful to sit down with a mediator who can try to help the parties find a way to make things work. And then as a last ditch effort, what we can do in the 13 is take the missed payments and spread them out over 60 months. Some people are so far behind, it doesn't matter at that point, but let's say you're 5 months behind and the lender says you got 2 options: either sell the house and pay us, or, come up with one big lump sum of 5 payments. And most people can't do that. So at least with the Chapter 13, we can take those 5 missed payments, stretch them out over up to 60 months, and then you just have to pay 1/60th of the arrears. At the end of it, you're done with your bankruptcy. You might have wiped out some other debt that you might have at the same time, and you get to keep the house. And the other benefit of that is, a lot of the modifications that they're doing nowadays are based on current interest rates. So it's not, somebody got a 3.5% interest rate 10 years ago. They don't want to necessarily modify their loan because it's going to be 7% now. So if you just get into the 13, pay back the arrears, your loan's still at the nice low interest rate, and you get to start over there.
So if a homeowner, okay, let's say a homeowner is facing some financial difficulties right now and they're behind on their monthly payments, but the foreclosure date they've already gone through a notice of default and the foreclosure date has been set. A filing for Chapter 7 or Chapter 13 will kind of push that off and stop the foreclosure from happening. Is that correct?
Yes. Yeah. So what you get is what's called an automatic stay. And the automatic stay halts and kind of freezes everything. So the lender can't foreclose, your creditors can't call you, they can't sue you, they can't garnish you. So it kind of stops all the collection efforts. In the Chapter 7, it's only going to buy you about 3 months. And in fact, if the lender wanted to, they could file what's called a motion for relief from the automatic stay, which would lift the automatic stay and allow them to proceed with the foreclosure. So the 7 doesn't have as many benefits because you're discharged in 90 days. So when the case is discharged, the automatic stay goes away. Or if the lender really wanted to, they would file a motion to lift the stay and could get it done sooner. They typically don't do that because it is going to take 30 to 60 days for them to lift the automatic stay. And they're like, why not just wait the 90 days till you get your discharge in the 7? In the 13, it's a little different because you usually are proposing something, either a modification through the program, you're offering to repay the arrears over time, or some other proposal, and so the lender is less inclined to try and lift the automatic stay because you're working on some sort of proposal that's going to work for everybody.
So basically, you come up with an idea, or like who comes up with that
Yeah.
proposal?
So we come up with a plan or a Chapter 13 bankruptcy plan to address how we're going to do the arrears. Either we propose we're going to try the modification program, and if that doesn't work out, we're going to re-amortize the arrears, or just from the beginning say we're going to do the arrears, or say, we're not going to include it at all. We're just going to list it for sale, but that doesn't buy as much time as you would possibly want, and that may trigger the lender to file the motion to lift the automatic stay.
Are there any California laws that specifically deal with homeowners filing for bankruptcy that own property?
So the biggest one, and actually changed rather recently in 2020. So before 2020, what we call a homestead exemption, which is the amount of equity you're allowed to have in your primary residence when you file bankruptcy, was only about 100,000. And so you can imagine for people in California, that's not a lot of equity with the appreciation that we have here.
Especially over the last
So,
few years.
yeah. And so in 2020, they actually changed it. And now it's a minimum of 300,000 and can be up to 600,000. And so that was huge in 2020, and it increases for inflation. So it's actually higher. It's about 250 right now because it's gone up in the last 4 years.
So when you're saying if somebody homesteads it after 2020, that homestead amount is up to 300 to 600,000. Is that what you said?
So it is a little confusing. Actually, in bankruptcy, you don't need to physically have recorded a homestead exemption or homestead deed on the property. When you just say it's my primary residence, you get the homestead exemption in bankruptcy. And so, yeah, the equity would be up to almost $650,000. So if you have $1 million loan and you owe 500,000 on it, the 500,000 in equity is exempt in the bankruptcy. So that's the important part. Otherwise, you wouldn't be able to get the benefit of a Chapter 7 or 13 if if the equity you had was greater than 100,000. Now it's protected up to 650,000.
I mean, that's huge because
Yeah.
that could protect so much of a homeowner's assets while you're filing for bankruptcy.
Yeah. So it's
That's
just that was it's been a long time coming. I mean, most, Nevada, it's already 650,000. Other states have much higher homestead exemptions. California, it's been low for, forever. And it's been, I don't know what took them so long, but finally in 2020, they changed it. And so that's been the biggest change for people.
Yeah, you'd think that California would be faster at doing things like this because they're usually at the forefront of
Yeah.
any kind of legislation, but because there's a lot of legislation in California. But I'm glad that they finally got their act together and made that exemption. That's
Yeah,
huge.
it's so important because that's the first question anybody's going to ask, right? You talk to a bankruptcy attorney, and so many people think, "Oh, I'm filed for bankruptcy. I'm going to lose my house." And it's like, no, you're protected up to $650,000 in equity. So as long as you don't have more than that, it's not a problem. And so that's their biggest asset and their biggest concern. So it's nice that we have that had just changed recently. So
So if a homeowner wants to sell their property while they're in bankruptcy, can they do that?
they can, but they need court permission. If you're going to buy a car or house, you need to have permission. So, it's not too complicated of a process, but it does cost fees and there's a motion and it needs to be dealt with. So it's not unheard of, especially in the Chapter 13. People can actually buy homes when they're in the 13. So we file motions all the time for somebody who's in a Chapter 13 for 5 years, and lo and behold, they want to buy a house. So they go, they get qualified for a loan, and they buy. We have to submit the information to the court to get it approved, and then they go and buy their house.
Well, that brings me to another question. So a lot of people are super concerned about what it's going to do to their credit. So if somebody files for bankruptcy, like how does that affect their credit? And can they eventually buy real estate down the road? It sounds like they can.
Yeah. So the bad news is it does stay on your credit report for 10 years, but it doesn't mean you have bad credit forever, and it doesn't mean you can't buy a home forever. Really, right now, the FHA waiting period after a Chapter 7 bankruptcy is only 2 years. So
That's not
assuming
bad.
you don't get yourself in trouble again and are able to rebuild your credit slowly, you can apply for an FHA mortgage 2 years after a bankruptcy. And so I've had plenty of friends that do that, especially if you have a VA loan or eligibility, and you file Chapter 7 2 years later, dollar down and you get a house. So, but
That's
you,
great. So, I mean,
yeah,
obviously, it will affect your credit because you're forgiving a lot of debt,
yeah,
but you can still purchase a property after you've gone through bankruptcy. So that's the good news, and
yeah,
it gets you out of a situation that you didn't want to be in the first place.
yeah. And the good part is when you file for bankruptcy, a lot of times you're paying off this debt over time. And when you're looking at, paying off credit cards, and could take you, 10, 20 years to pay off, or you can be done with it in 90 days and be applying for a loan in 2 years. If you've got, even as little as $20,000 in debt, but at 30% interest, it could take you a really long time to pay that off and to be able to qualify for that house that you're looking for.
Yeah, especially in California too, where, as you said, over the last 4 or 5 years, our appreciation has gone through the roof. So if you have a home and you've owned it for the last 5 years, you've definitely had some equity built up because of the amount of appreciation we've had.
Yeah.
So you do have some more wiggle room there. That brings me to my next point. So what happens? What should a person expect to pay for a bankruptcy? I know that everyone's financial situation is different. So I assume that there's a scale of how much is involved for fees for a bankruptcy. Is that correct?
Yeah, it depends on how complicated the case is, but if it's a fairly straightforward Chapter 7 bankruptcy, we have a couple of options, but it's about $1,400. And if you want to make payments on it, sometimes it's a little bit more if we offer a payment program. So it can be that, but that's also including a $338 filing fee. Plus, there are 2 online classes that the bankruptcy court requires. They're not really expensive, about $15, $20, but we include that in our fees. And then we also run a credit report, which can cost $50 to $60. So we try to include all that in the fees, so there's no hidden costs for the people who are filing. So it's fairly inexpensive. We actually see a lot of people during tax season right now because people are getting tax refunds. And if you're getting $4,000 or $5,000 back, people are either looking at, do I take that money and try and pay down some of my debt, but might be more than that, or do I just take $1,400 and file for bankruptcy to wipe it all out? And so we see a big uptick during this time. We also see a big uptick during tax season because the creditors know that people are getting tax refunds and may have money to
That
settle
makes sense.
debt. So it's an interesting cycle that people are in.
So I assume that a bankruptcy is like there's a lot of work involved, a ton of paperwork. Is that accurate? Like, what should a person expect to bring to a meeting with you when they're first starting for filing for bankruptcy?
So when they're first filing for bankruptcy, I guess the most important thing is to see whether they qualify for Chapter 7 or 13. So it'd be really helpful to have their 6 months of pay stubs, because that's what the court's going to want to base their annualized salary off of. So we look at 6 months of pay stubs, and we figure out whether you qualify for the 7. Or if you're over the median income and you have to do a 13, it's best to have that information, because then we can try and estimate what the payment's going to be for their Chapter 13.
So only 6 months of paycheck stubs and a driver's license. Anything else? I mean, that seems super simple to me.
So if you decide to move forward, the court only requires 6 months of bank statements, 2 years tax returns, and a copy of your social security card on top of it. So we try to keep it very, very simple, very straightforward. They don't want to see too much, and we don't want to give them too much to see.
So what are the biggest concerns that people have when they come to see you for a bankruptcy?
So I think most people think when you file for bankruptcy that you're going to lose everything, your house, your car, all your money in your bank account, and that someone's going to come to your house and start taking things off the wall. And what really happens is, you have exemptions that cover almost everything, all your basic assets. So you're not going to lose your house for your primary residence because it's exempt. Your car is usually going to be exempt. You just have to give estimate of your personal belongings. Nobody comes and looks and sees what you have in your house. They're not going to take your TV off the wall. Again, you have exemptions for money that's in your bank account, so that's not going to happen either. So our job, and my job as a bankruptcy attorney, is to make sure that you tell me all your assets and I use all the exemptions properly to make sure that the trustee is not going to want to take anything. Because that's the way the trustee makes money, is by trying to find assets that are non-exempt and to sell those to pay towards your creditors. So our job is, and most of our cases are what are called no asset cases, meaning there are no assets for the trustee to move forward. So.
Yeah, I'm sure that would be very, very nerve-wracking. If you're going to file for bankruptcy, you're like, oh my gosh, I don't want to, where am I going to live? I'm going to be homeless now. Like that is nice to know that if you file for bankruptcy, your house will be exempt. But you can sell it with the judge's approval if you need to recoup some of that equity and pay off some of your debt.
And sometimes, we're filing bankruptcy, either 7 or 13, just to buy some more time to sell that home. And you don't even need court approval if we just dismiss the bankruptcy before the sale. So then you can move forward with the sale without getting court permission.
Oh, perfect. Good. Well, Rory, I really appreciate your time today. If anyone wants to get a hold of you in order to talk to you about bankruptcy, how do they get a hold of you?
Sure. They can check out our website, which is vowinklellaw.com. I know that's hard to spell. It's V as in Victor, OHWINKELLAW.com. Or they can call us at 702-735-1500. And even though it's a Vegas number, we also have offices here in California.
So you're licensed in California and in Nevada?
In Nevada, yep.
Perfect. All right. Well, thank you so much for your time. And if you have any questions about real estate and the bankruptcy, I can handle the real estate side of things. So if you are a homeowner that does need help with a bankruptcy and selling your home, let me know. We are a great team and we can help you find a good solution for your situation.